In this video, we will cover the UCC's gap filler provision relating to price, Section 305 of Article 2. Like quantity, price, how much the goods are to be sold for, would seem to be so central to a transaction that if the parties have not agreed on a price, then there's probably no intent to be bound yet. Unlike quantity, however, an open or indefinite price term in an agreement can be filled by the UCC. But because, like the quantity of goods involved, the price is so central to a transaction, any consideration of an agreement that leaves open or undefined a price term must start with subsection 4 of 305. That subsection reads that where the parties intend not to be bound unless the price be fixed or agreed, and it is not fixed or agreed, there is no contract. So where a purported agreement for the sale of goods leaves open the price for the goods involved, we must ask the question that one should always ask when an agreement leaves open or indefinite a material term. That question is, did the parties actually intend to be bound to a bargain? After all, price is always a material term in a contract for the sale of goods. Parties who intend to create binding obligations rarely fail to address the issue of price. Recall that the common law of contracts and the UCC, as a consequence of its reliance on the common law, uses an objective test to determine the parties' intent, looking to objective factors to determine whether the parties have manifested an intent to be bound to a bargain. If the parties have not reached an agreement on price, then perhaps that is objective evidence that the parties did not intend to be bound to anything, that no contract has been formed yet, not until the parties were able to clarify their intentions as to price. Stated differently, the absence of an agreement on price is itself an indication that perhaps the parties were still in the negotiation stage of bargaining. Subsection 4 of 305 reflects that intuition, that a court should not provide a price term unless the facts indicate that the parties intended to be bound to a contract. Absent an intent to be bound, the court should find that the parties never formed a contract. But if it is clear, based on objective evidence, that the parties did intend to be bound to a deal, then subsection 1 of 305 confirms that a contract is formed despite the absence of an agreement on a specific price. In that case, a court can resort to the gap fillers provided in subsections 1 and 2 of 305 to provide the price term for the parties' agreement. Determining the applicable price for the goods depends on what the parties' agreement says about price. Subsections 1 and 2 of 305 together describe four possibilities. First, the parties' agreement may simply be silent on price, so the parties' agreement omits any term regarding price, even though, based on objective evidence, the parties intended to be bound to a deal. Second, the parties' agreement does address price, but only to say that the parties will mutually agree on a price at some later point in time, but then the parties fail to agree. So the agreement is a classic agreement to agree. Third, the agreement says that the price will be set by reference to a market or some other third-party standard, that is, a standard set by someone other than the buyer or the seller, but the market or third party then fails to set a price for whatever reason. And fourth, the agreement says that one party, either the buyer or the seller, will have discretion to unilaterally set price. For the first three scenarios, subsection 1 of 305 provides the applicable gap filler. That subsection says that the price for the goods will be a reasonable price at the time of delivery, with a reasonable price depending entirely on the circumstances. But a court would usually base a reasonable price on the fair market value of the goods, that is, the price that other buyers would buy and other sellers would sell the same goods in an arm's length transaction. Where the goods are fungible goods, for example, commodities like grain, fruit, oil, or lumber, the fair market value may be relatively easy for a court to determine, because there may be some commodities market or exchange that provides the market price at any given day or time. For other types of goods, the court may need to look to other types of evidence to see what a reasonable price for those goods would have been at the time of delivery. For the fourth scenario, where the parties' agreement says that one party, either the buyer or the seller, will have discretion to unilaterally set price, subsection 2 of 305 provides the applicable gap filler. That subsection says that the party who is entitled to set the price must do so in good faith. So the party that is contractually entitled to set the price does not have absolute unbounded discretion. For example, let's say you offer to buy my old beat-up car and say, name your price. Upon hearing this excellent offer, I immediately say deal. So I have objectively manifested assent to your offer. Stated differently, we now have a contract pursuant to which the price for my car is the price that I specify. In this kind of contract, I cannot demand any price that I want. For instance, I cannot demand a price of $1 billion and contractually require you to pay that, because in setting a price, I am subject to the implied duty of good faith. Remember, good faith ordinarily has two components, an objective component and a subjective component. And in demanding $1 billion for my old beat-up car, I may well be breaching both components. With respect to the objective component, because my car is not worth anywhere close to $1 billion, demanding such a commercially unreasonable price may show my lack of objective good faith. With respect to the subjective component, if I decided to demand such a high price because I changed my mind about selling my car, or maybe because I found another buyer that I would prefer to sell my car to, then the $1 billion demand may show my lack of subjective good faith in setting the price of the car. I am acting dishonestly or opportunistically to avoid selling you my car. There is an unsettled question in the case law as to what good faith requires in this context. All courts agree that good faith's objective component applies. The party setting the price must in good faith set a commercially reasonable price, a price that is consistent with the market price for the goods. Stated differently, a price that is commercially reasonable. Where courts disagree is on how much scrutiny should be applied to the subjective component of good faith. For example, what if the price is set within a commercially reasonable range, but the price is set at the higher end of that range for some ulterior motive? Under these facts, the court in Mathis versus Exxon Corporation, which is excerpted in your reading, held that good faith in this context requires both components. Stated differently, the same dual good faith duty that applies in all other contexts also applies under 305. The party challenging the price set by the other party may challenge either the commercial reasonableness of that price or the subjective honesty of the party setting the price. The facts in Mathis suggested that the prices were set by the seller, Exxon, in a way to drive its franchisees, the buyers, out of business so that the franchisees would not compete with Exxon's own gas stations. But as the reading notes, most courts disagree with the Mathis decision. For example, in Autry Petroleum, which is also excerpted in your reading, the court points to comment 3 to section 305, again highlighting the influence and importance of the official commentary to the UCC. That comment says that in the normal case, where the price is to be set by reference to some market price, there is a presumption of good faith. So the comment suggests that the commercial reasonableness of a price is all that matters in this context. Stated differently, all that is required is objective good faith, not subjective good faith. Courts arriving at this conclusion have reasoned that when a price for goods is consistent with the prevailing market price, any scrutiny into the subjective intent of the party setting the price invites needless litigation and judicial second-guessing. So rather than requiring both subjective and objective good faith, where the price is set within a range of commercially reasonable prices, the party setting the price enjoys a presumption of good faith. But even if you find this reasoning persuasive, note, it raises its own difficult question, namely, how exactly then is the requirement of good faith under subsection 2 of 305 any different than the requirement of reasonableness under subsection 1? After all, if the drafters of Article 2 meant good faith under subsection 2 to simply mean a reasonable price, why do they include subsection 2 at all? Why not fold it in into subsection 1's reasonableness standard? So in this video, we covered Article 2's gap filler provisions relating to the price of goods, how the gap filler provision applies in situations where the parties have manifested their intent to be bound to an agreement concerning the sale of goods, but have not specified a price for those goods. In the next video, we will conclude our look at the UCC's gap filler provisions by focusing on Article 2's various gap filler terms concerning delivery of and payment for the goods.